When the motion to dismiss hearing was over, roughly an hour and a half after it began, it was only 7:30 a.m. in San Francisco. The day hadn't even started yet, and Think had already been delivered a crushing blow. They tell us that companies are people too. Strangely, I was the one who felt the punch in my gut. At first, it was hard to believe that what I had heard was even real. How could any reasonable person think that this case, the Seinfeld of lawsuits, a lawsuit about nothing, should proceed? As I processed the back and forth, I realized that this was not just about Joe Johnson anymore. I was fighting seemingly everyone involved. Of course, Johnson, this guy who I had still never even seen a photo of, who lied under oath, though for a convicted forger, I mean, come on, what was anyone expecting? Dirk, who added to the confusion, Larry J. Feldman, who lied to the judge, the Maryland Attorney Grievance Commission, which allowed Feldman, a lawyer indefinitely suspended from the practice of law, to once again practice law, and Judge Anderson, who thought that an anecdote from her own life was more important than the facts of the case. Plus, Paul and Public Citizen, who simply abandoned Think. But being upset at everyone wouldn't get me anywhere. I needed a plan. I needed information. It dawned on me that to win this case, I would effectively need to take on the state of Maryland. And to do that, I needed help. From Think Press and PlainSite, this is Broken, a podcast about what we like to call the rule of law, and how in the United States there isn't one. We'll talk about all aspects of the legal system through the lens of PlainSite, a legal and financial research platform where you can find information about things like lawsuits, lawyers, companies, and judges. On PlainSite, anyone can read anything the government produces for free with no account. It really does put the world's complexity in plain sight. If I was deep into the proverbial tunnel, I wasn't yet at the point where I could see the light at the end. And I wasn't really sure there was one. It seemed just as likely that the tunnel led to an underground cliff that just left off at an abyss. But I was determined to keep going, because there was just no way that I was going to let Joe Johnson win. As I sat at my desk thinking about what I had just heard in court, audio that wasn't instantly replayable since court rules prohibit making a recording of your own and I wouldn't receive a recording I still had to purchase for weeks, another hearing involving Joe Johnson was already starting back to back before Judge Anderson in the separate case of Johnson versus Spirion Incorporated. As best as I could with no access to documents, I'd been following the Spirion case for a bit because procedurally it was essentially parallel with my case, which meant that it might give me some clues. But randomly, my case's hearing was scheduled first, at 9 a.m. on March 12th, so I couldn't use anything from the Spirion hearing right after to my advantage. Judge Anderson began in Spirion by noting an interesting quirk, that Johnson had two different lawyers for his two different cases before her that morning. But before he engaged a lawyer for what's called a special appearance at the hearing specifically, just as he had in my case, Johnson had made the grave mistake of filing a motion before Judge Anderson to refer Spirion and its lawyers to the Maryland Attorney General's office for some bogus reason involving whether or not Spirion was actually licensed to do business in Maryland. He argued that even though Spirion was not based in Maryland, because Spirion wasn't paying Maryland taxes, it couldn't defend itself in a Maryland lawsuit. It was crazy, and that's exactly how Judge Anderson saw it. She told Spirion they could request attorney's fees for the time spent on the motion. This was only one of several frivolous motions Johnson filed, and it took a few minutes for the judge to get reacquainted with them all. This is when Judge Anderson revealed the reason why she was assigned to both cases. Think's case number ended in the number 8, and she was the 8 judge. But the Spirion case number ended in 0, and the 0 judge had asked her to fill in because the second to last digit in the case number was also 8. So she was effectively serving double duty as both the 8 judge and in this instance as the 0 judge, which meant that by sheer happenstance, she got to observe how Joe Johnson behaved in both of these cases, one after another. The Spirion case was about Johnson's allegation that a low-jack anti-theft tracking device installed in his BMW was defective. You may recall that Johnson had also sued BMW itself in a separate matter over its 3G connectivity. The The allegations sounded suspicious at best. After Johnson sued, Spirion gave him a new device as a gesture of goodwill. Johnson dismissed the case, and then Johnson undismissed it, alleging that the device still didn't work. He then managed to get a default judgment for $2,500 by, surprise, not serving Spirion with court papers that he was required to serve. Spirion viewed this as a way to never deal with Johnson again and agreed to pay the $2,500 instead of continuing to offer his replacement LoJack ongoing connectivity. Yet, even after being paid, Johnson still pursued his litigation by filing another lawsuit requesting a jury trial in the circuit court, arguing that he was entitled to both a monetary judgment and continued LoJack service effectively forever, essentially arguing that he could force LoJack to accept him as a customer. That additional lawsuit was the one this hearing was in. After about 30 minutes of just explaining what had happened across 3 dockets before 2 courts involving 2 different corporations connected to Spirion, Judge Anderson got the picture. She spent 20 minutes after that sounding outraged, far more outraged than she had in Think's hearing, noting that Johnson hadn't been truthful, and finally, she dismissed the case. She decided to set yet another hearing to hear arguments over attorney's fees. There was a lot to process. I felt like I had just been bamboozled, and I was determined to figure out exactly how. Judge Anderson had only gotten the full picture of how Johnson operated well after Think's hearing was over and done with. Still, she would probably forget it all anyway by the next time she heard the case. It would have been nice if there had been a neat, clean conclusion to Spirion, but there is always another delay, always another hoop to jump through sometime in the distant future, and I needed to be able to prove beyond a shadow of a doubt that I was right, and I needed to do it now. I started working on a draft of a motion for reconsideration, but before I could even finish it, the next day, I received an email from Johnson's lawyer for my case, Larry Feldman. Fresh off his victory by keeping the case rolling, Feldman was offering a settlement deal. For the low price of $15,000, Joe Johnson would go away. Sort of. Because as I knew from Spirion, just because Joe Johnson said he was going to dismiss a case didn't mean that he was actually going to dismiss the case. It was the formal expression of the extortionate threat that Johnson had been making the entire time. Feldman was also demanding, quote, permanently removing any reference to my client from PlainSite. I said no. And then I realized that what Johnson was really up to was probably, at least so far as I could tell, insurance fraud. Because while my company didn't have a general liability insurance policy that covered litigation like Johnson's, most big companies did. An insurance company wouldn't hesitate to pay $15,000 to make someone like Johnson go away, even if the claims were clearly fraudulent. Insurance math says, why spend $150,000 to fight a battle that could be avoided for the tenth of the cost? But my math was different. It said that my budget was zero, and that I wanted every penny I was spending back, and Johnson in prison. Maybe Johnson saw Think Computer Corporation on PlainSite and thought it was just another big company to target that would roll over like the dozens or hundreds of others he had targeted. If so, he miscalculated badly. Before, I had been emailing lawyers. Now I started emailing everyone else. Reporters for the Baltimore Sun and the Washington Post. Maryland legislators who had failed to fix the state's joke of an anti-SLAPP statute, which apparently its judges didn't even know about. The administration running the Maryland judiciary, which had let this go on for far too long. And the clerk of the Prince George's County Circuit Court, because I had some questions. I had queried all of the court data I had about Johnson in PlainSite to see if there was any mention of him being vexatious in the docket metadata. And in fact, there was, in a 2015 case I thought I had already looked at. It was called Johnson v. Maximus Incorporated, and it involved 4 dockets. One for the Maryland State District Court, one for the Maryland State Circuit Court, one for a Maryland State Appellate Court, and one for the District of Maryland Federal Court. Since the case had been in federal court, I'd been able to read some of the documents on Pacer, which is why I remembered it, and it was another case about Johnson's student loans. What I hadn't realized was that after Maximus was removed to federal court, it was remanded back to state court, and that's when the issue of Johnson's vexatiousness came up, meaning that those documents were never on Pacer. I was pretty sure the court clerks in Prince George's County hated me with a passion. On call after call, I had explained to them that I could not use the kiosk in the court because I was 2,000 miles away, but they never seemed to care. On March 19th, I sent an email to them nonetheless requesting 5 documents from the Maximus case that had been filed after the federal court had sent it back. I didn't know if the now 8-year-old paper documents were stored in a warehouse or if they were still somewhere at the court, but I figured it couldn't hurt to ask. Much to my surprise, 2 days later, I received an email back from Taylor Bowen, the lead judiciary clerk, with 8 attachments. The documents I had requested in electronic format, free of charge. It was a judicial records miracle. What the documents actually said made my jaw hit the floor. 8 years ago, there had been a colossal legal battle over the exact same issues I was fighting over now before the exact same court. Maximus Incorporated and a company called Financial Management Systems Incorporated had been on the receiving end of Joe Johnson's ceaseless abuse of motion practice and legal procedure, and they'd had enough. They requested a hearing to have Johnson declared a vexatious litigant. There was a transcript of the hearing, and at the end of the hearing, he was declared a vexatious litigant. The very court that I was litigating in had already declared Johnson vexatious, and then, after that, it forgot. The papers disappeared into some dingy room. It took 6 years for the court to adopt an electronic filing system that could store PDFs at all, and then it took 2 more years after that before I was furious enough to demand that someone scan them in. There was unfortunately a hitch, because after Johnson had been declared vexatious, in a kind of maneuver I'd never seen before, Maximus, Financial Management Systems, and Johnson all reached a settlement, and as part of that settlement, the parties convinced the judge to vacate the order that actually said that Johnson was vexatious, after it had already been set in stone. Perhaps for that reason, even though there was a paper record called a daily sheet of the order being filed, the order itself was missing from the file. I called Taylor Bowen to ensure that it hadn't just been left out of the scanned documents by mistake. She confirmed that it was never in the folder as long as she'd been aware of it. To my mind, it didn't matter. Whether or not the order was vacated or anyone could find it, the fact was that the transcript showed in black and white that Joe Johnson had been declared vexatious by a judge of the Circuit Court of Prince George's County, Maryland. And what's more, there was a recording. I had to get it. I placed the order with the court immediately. Proof of the core contention behind Think's legal defense was well worth the $20 and $2 payment processing fee. But I wasn't done. Now that I could read the Maximus motion briefs and transcript, I knew there had to be even more damning evidence out there. In the Maximus case, Johnson had threatened and harassed the lawyers by email, just as he had when he sent my mother that bizarre message threatening criminal prosecution from Saudi Arabia. I ordered a transcript and a recording from yet another case involving Geico, where it looked like the issue of Johnson's vexatiousness had also come up. The problem was that once I had all the audio files and PDFs, I somehow had to put all of this evidence in front of the court. Clearly, if I had depended on Dirk Schwenk to do the job in full at $450 an hour, we never would have known about any of this material, so I really didn't savor the idea of paying him more. Nor did Paul Levy, our public citizen, look very good, having abandoned Think as a client entirely on the basis that I had supposedly libeled Joe Johnson by calling him vexatious, when the very court we were litigating before had done the exact same thing, meaning that the statement could not be libel because it was true. This is why I didn't trust lawyers, even my own lawyers, because 9 times out of 10, they were wrong, too obsessed with irrelevant precedent or some stupid procedural rule or making their billable hour quotas to actually examine the facts. Put another way, the truth is always the last thing on the average lawyer's mind. This especially described Larry J. Feldman, Johnson's lawyer for the hearing. I was extremely upset that he had lied to Judge Anderson, and I spent a few hours drafting a letter to the Maryland Attorney Grievance Commission about it. I had no illusions of lawyers typically facing accountability from state bars or regulatory bodies like the AGC, but given that Feldman had already once been indefinitely suspended from the practice of law by the AGC and was supposed to be practicing under the supervision of an unnamed monitor, I figured it was worth a shot. Also, given that I'd heard from both Paul and Oliver that Johnson had baselessly reported them to the AGC before they withdrew, it seemed only fair to file something against Feldman that actually had merit. Feldman clearly didn't care about the truth in this case, but I most certainly did. I wanted to know everything there was to know about how I got dragged into this mess. I pulled up the Maryland Judiciary's Form MDJ-004 again, the one that you were supposed to get notarized in order to be granted electronic access to your own case. In all of the notarization fields, I just wrote unconstitutional in all caps. And then I added the case numbers of the other Johnson lawsuits I wanted to be able to see, especially the Spirion and Geico cases, as well as another case that had been filed on the same day as Johnson's case against Think. Of course, despite repeated phone calls and emails in which I tried to explain how the First Amendment was supposed to work, the form was rejected. I even spoke to Carly Roche, Special Assistant to the State Court Administrator in the Maryland Administrative Office of the Courts, who assured me that she understood the situation, and I think she really did. At first, she was out of the office for a bit, but when I followed up a few weeks later after hearing nothing, she was no longer employed by the Maryland judiciary. On March 26th, I decided to try a long-shot idea that would make it much easier to submit the evidence I'd uncovered to the court. I would personally try to intervene as a defendant in my own company's lawsuit. I filed a motion to intervene, and as an exhibit, I attached a proposed motion to substitute Aaron Greenspan as a defendant, dismiss, issue sanctions, and redeclare Joseph R. Johnson Jr., aka Joe Johnson, a vexatious litigant. Then I just had to wait for the judge to rule. I also filed a motion in the Spirion case requesting MDEC document access under the First Amendment since my form had been rejected. It was ridiculous that I couldn't see what was being filed in a parallel case which could affect my own, involving the same plaintiff and the same judge. Of course, the court rejected the motion for no coherent reason, so I couldn't even file it. Dirk let me know that since we hadn't prevailed on the motion to dismiss, we needed to file a formal answer to the parts of the Third Amended complaint that were still active. He went ahead and filed one without my reviewing it since it seemed like such a straightforward filing. When I saw it pop up on MDEC the next day, I couldn't believe it. It was probably the sloppiest legal document I had ever read. The most glaring issue was that there were a number of verb conjugation problems. There were 2 paragraph 1s and 2 paragraph 2s up through paragraph 6. The second paragraph 1 said, "Defendant anticipate raising the issue." The second paragraph 2 said, "Defendant anticipates raising the issue." The second paragraph 3 said, "Defendant aver." The next paragraph said, "Defendant avers." Paragraphs 5, 6, and 7 said, "Defendant aver" again. 8 said, "Defendant avers," before 9 went back to the kind of grammatically incorrect me Tarzan language that you might expect someone who is drunk to put in a legal document. The last paragraph began with the words, "Defendant raise." I was not pleased. I informed Dirk and he filed an amended answer. On March 29th, the next hearing in the Spirion case was scheduled, the hearing where Judge Anderson would finally hear argument about attorney's fees. I asked the court by email if I could observe via Zoom since the court's web-based form to obtain a link basically never worked. I was told to try again because the form only supposedly functioned for specific time slots right before the hearing. Eventually, I got permission. The hearing lasted nearly 3 hours, but that wasn't enough because Judge Anderson didn't actually make a decision. The Gordian knot that Joe Johnson had managed to tie around multiple Spirion legal entities, different dockets, absurd legal arguments, and at least one mysterious phone call where it seemed like someone had impersonated Johnson's attorney to the court was just too thick to cut through. Judge Anderson continued the matter to yet another hearing scheduled for April 15th. The next day, on March 30th, Dirk served Johnson with a few discovery requests I'd written up. There was no point in bothering with interrogatories, since Johnson seemingly just lied about everything. But I figured document requests might yield some interesting evidence. After that, I thought I'd just have a peaceful couple of weeks before the next hearing, but Johnson was determined to make sure that wouldn't happen. On April 8th, he filed a request with the Clerk of Court for a subpoena targeted at a company called Dynadot LLC. Dynadot was a domain name registrar that Think had just started to use maybe a few weeks before, but it had absolutely nothing to do with Johnson's case. It wasn't the domain name registrar Think had used in 2022 or 2023, and moreover, domain names had absolutely no relevance to anything in dispute. Johnson clearly had no idea how the internet worked. When I read the subpoena request, I couldn't believe the court had even let him file it. Clerks had the power, as I had often been reminded, to reject spurious filings. Yet they went above and beyond for Johnson. The next day, the court issued the subpoena to Dynadot. "You are hereby compelled," it said, "to appear and produce the following documents, electronically stored information, or tangible things." Then there was a colon, after which the subpoena specified, "to produce documents, items, and information." Without limitation, every document, item, and piece of information Dynadot LLC had ever generated or come across. It was patently absurd. Dynadot was instructed to produce all of these likely millions of documents in person at Johnson's P.O. Box. 48 hours later, the Maryland judiciary had turned the crazy dial to 11. Not only did they allow Johnson to request the broadest subpoena ever, and not only did they then issue it basically immediately, but 2 days later, they disappeared it all from the case docket as though it had never happened. This would have been a major scandal in a federal court. In Maryland, erasing court records electronically, proving incompetence of both the party to a case and the court itself, barely merited a yawn. Nonetheless, I wrote to the court administration about it because even if they didn't care, I was pretty incensed. Of course, no one ever replied. 4 days after that, it was finally April 15th. And it was, in a way, I guess, worth the wait. I once again got permission to observe over Zoom, and for the first time in my life, once I logged onto that video meeting, I was confronted with something I had never witnessed before, an image of Joe Johnson. He was appearing remotely, probably from his home, but it was hard to tell because he had chosen a fake background. It looked kind of like the lobby of a hotel or an Airbnb with staging furniture, with encouraging, positive words in the background. Frankly, it seemed like the kind of background an upper-middle-class white woman might choose. But Joe Johnson was not an upper-middle-class white woman. He was most definitely an African-American man with what appeared to be a skin tone dark enough that it was hard to make out his features. I wondered how much this had to do with my present situation and his. As always, Johnson sounded calm and collected when he spoke, but simply glowered when he wasn't speaking. After about 40 minutes of testimony, including testimony from Joe Johnson himself, Judge Anderson rendered her ruling from the bench. She found that Johnson had filed the case in bad faith, that his motions were frivolous, and that he owed Spirion $84,321 in attorney's fees. I was truly shocked. Here's Judge Anderson in her own words. The audio has been edited for clarity and time.
The court finds that there was definitely a lack of substantial justification. Mr. Johnson took the stand when you all were in court in person before me. I believe it was last week, if that's the proper date. March 29th was the last date we were in court. And so the numerous pleadings that have been filed in this case, the court finds were in bad faith and without substantial justification. And I say that because of Defense Exhibit number 1, the Better Business Bureau response. This was at the same time this filing was going on. Mr. Johnson testified that he believed the money for the judgment was in response to the Better Business Bureau, but there was nothing, no other evidence indicating that. He also indicated in his testimony that he didn't know they were different entities and things of that nature. In this Better Business Bureau complaint, which is Defense Exhibit number 1, he said he purchased the LoJack stolen vehicle recovery system. Spirion purchased the LoJack Corporation through acquisition. And in doing so, it legally acquired all of LoJack's assets, including user agreements and contracts, and became responsible for all aspects of its predecessor. So he writes this in his email. He indicated when he testified that indeed he did send this email. This is an exact opposition to what he's trying to argue today, that he didn't know that the parties were not the same entity. Mr. Johnson testified that he's gone to paralegal school. Obviously, he is filing motions pro se and not, he was until the court informed he needed to get an attorney for some of the things because he continued to file when the court said it was inappropriate to file certain things. I explained that he needed an attorney, and he did do so. And he's indicating here that he knows the difference with regard to Spirion. He says what it is that they agreed to do. He's writing this here on April 6, 2022. Later, in November of 2022, that's when they have the Rule 3506B dismissal in the district court. That's in November of 2022. So he writes this first, but then the dismissal is done then, and then he files a motion to vacate December 1st, 2022. So there's no way, there's many things that have happened since he filed this Better Business Bureau complaint to think that this was in relation to that versus in relation to the agreement they had reached in which he asked to vacate that dismissal. So the court does not find his testimony with regard to that to be credible. So in seeing all of that, the court has looked at all of the pleadings that were filed that had to be responded to, the protective orders that had to be filed. What's happened is, and I do have reviewed the defendant's bills, and I do find them to be fair and reasonable based on the circumstances of this case. This is an unusual circumstance. This is not the normal amount of pleadings that skilled attorneys who've been practicing for decades would put into place. But nonetheless, this is a self-represented litigant who's had some amount of training through paralegal school, but he is filing motion after motion after motion that have to be responded to. In this case, the court found that it was a motion with regard to things that you already knew had been dismissed and we're trying to file it again. And the court will point out that they responded to the motion. They started to file the motion to dismiss. And then at the same time they were filing that, they filed it. And then he then did an amended, he filed a motion to amend his pleadings. He didn't go speak to a lawyer. He filed, Mr. Johnson has left the Zoom.
You heard that right. When things started to sound real bad for Johnson, he just noped out of the Zoom hearing. Now, this was chalked up to a dead battery, but ask yourself, if you were on the hook for $80,000, would you bother to plug in your phone?
He was just on and he's just left, I guess, in a few seconds. I don't see him back in the waiting room. I'll keep it up, Mr. So I'm not sure, Mr. Kirk, if you'd like to reach out to your client. I'll pause for a moment before I complete my ruling, but I see that he has left the Zoom.
There's no response to the text messages I sent, Your Honor.
All right. So I'm going to continue with my ruling. You don't have any objection to that, Mr. Kirk?
I don't know how I could, Your Honor.
Okay.
Yeah.
I just want to be clear for our record.
Yes. I on these circumstances, I have no reason to believe that he shouldn't be here based on everything I know. Your Honor, I was able to reach Mr. Johnson on phone. I'm glad I did that, Your Honor. He did say he had a power outage on the device he was on, and he's reconnecting to a device with power right now.
All right. So continuing, as I was stating that after the motion to dismiss was filed, and instead of responding to the motion to dismiss, a first amended complaint was filed. After that, the parties had to then file a motion to dismiss the first amended complaint. New research had to be done. More attorneys had to be employed. In this case, with someone, again, who is self-represented, who has some paralegal training, but is filing motion after motion after motion, in order for this firm to keep up with all the many motions that were filed, all the many issues that were raised in each of the motion, some of those motions frivolous in nature, they had to have one partner, two associates, and one of counsel respond, all of various rates. And in this case, given the nature of these filings, how I guess back to back these filings became, something was filed, something else was filed. In order for them to even keep up with these filings that were done, they had to have all of these different people working on this case at the same time, a case that had already been resolved in the district court. And that's where the bad faith comes in. As I said earlier, that there was no dispute that he'd already been paid in full on a judgment that he never served the other parties on when he wanted to vacate that judgment. There he is. All right, Mr. Johnson, you're connected to audio now. As the motion to dismiss was pending and the first complaint was being responded to, then several other things were being filed that they had to continue to respond to with 4 different attorneys at the same time. And based on Maryland Rule 1-341, the court finds that this was patently frivolous and devoid of any colorable claim, and that the sanctions under here are being awarded with regard to attorney's fees according to 1-341 in the amount of $84,321 because the court finds there was a clear, serious abuse of judicial process in these filings.
So, that happened, and it was extremely encouraging. The litany of bad faith acts Judge Anderson attributed to Johnson was almost identical to the list of stunts he had pulled in Think's case. In over 30 years of defrauding the courts, although he had gone to prison, Johnson had never been held financially accountable in a serious way. The $500 sanction the Fourth Circuit hit him with in 2001 after Circuit City's lawyers called him vexatious wasn't really serious. $84,321 was serious. Of course, Johnson immediately appealed. I really needed the documents stating that Johnson had filed a case before the Maryland Circuit Court for Prince George's County in bad faith and now owed $84,321 as a result. On April 16th, the next day, after fighting with the court clerk some more, I was finally able to file a formal motion in the Spirion case requesting MDEC access on First Amendment grounds. I pointed out that the court had already allowed me to observe the hearing the day before via Zoom because the First Amendment gave me that right. So it was unclear why I could not also use my First Amendment right to read documents. I attached a copy of the rejected MDJ-004 form, this time with several case numbers on it that I wanted access to. When the e-filing system asked me how I was related to the case, I chose interested party, which seemed accurate. A week later, when I was doing my daily checks of Johnson's active cases, I noticed something strange on the already insanely cluttered Spirion docket. It really was ridiculous. On April 16th, there were 9 separate entries that just said order. There was no description as to what order or what they were about. But that day, April 22nd, Joe Johnson had filed a document simply entitled line. It made me curious. I checked again later that day, and the description had been updated by the court clerks. Now it said line, and then in parentheses, order has to be ruled on before interested party can be removed. It was clear what was happening. Joe Johnson wanted me off his case's electronic service list because even though I couldn't view past filings by court policy, the practical reality was that going forward, I could be served with future filings because I was now listed as an interested party, and he definitely did not want me to see any of those. At 12:07 Pacific Time, I called the court and was connected to a member of the clerk staff named Kathy. To my utter shock, Kathy told me that someone had already called in that day and had told her, I am Aaron Greenspan, and that the other Aaron Greenspan had called because he was apparently tired of receiving court notifications and wanted his name removed from the service list. What? Was the only response I could muster at first. I explained to Kathy that I had not called in before that day. The only logical explanation was that Joe Johnson had, and had impersonated me to the clerk of court. It should go without saying, that's a crime. According to Kathy, the clerk of court did not record calls and had no record of the phone number that had called in previously because it showed up on their caller ID as anonymous. Kathy told me that my caller ID was showing up for her as Think Computer. Kathy said she couldn't send me the line document that Johnson had filed by email, but she was willing to read it to me over the phone. Quote, the clerk of court would please remove non-party Aaron Greenspan from the docket in the above matter as an interested person/party and remove the associated email address, with my email address, as a service contact for the above captioned matter. It then went on, quote, I hereby certify that on April 22nd, 2024, a copy of the foregoing line was served through the MDEC filing system on all parties and counsel of record. But of course, this was a lie, because I never received it. Even though I was listed as an interested party, Johnson made sure that I wasn't served so that he could sneak through his request. And when that didn't work, apparently, so far as I can tell, he decided to give the clerk of court a call, as me. Now, if you've been listening to this story roughly in order and you've been paying even a little bit of attention, you might have noticed a pattern here. Joe Johnson goes to prison in Virginia in the early 90s and then weasels his way out, for a time, by slipping a court order with the forged judge's signature into his own file while pretending to be a law firm paralegal. Joe Johnson is accused of stealing his mother's identity by his own sister. Joe Johnson goes to prison again for impersonating an attorney in a case involving his idol Bill Cosby and then lying to the FBI about it. Joe Johnson hires an attorney to make a special appearance at one of his Spirion hearings where that attorney denies ever having made a telephone call to the clerk of court about a strange filing connected to Johnson. And now, this. The only difference between the movie Catch Me If You Can and what I was witnessing is that Frank Abagnale, the check forger in the movie, actually made up most of his legendary biography. Joe Johnson actually did all of these things. Right away, I filed a declaration in the Spirion case to document what had happened. It made no difference. Within short order, my name and email address were removed from the service list by the clerk of court, which, as always, bent over backwards to accommodate convicted felon Joe Johnson, who now felt free to use my identity with government officials. I was both concerned and upset. Let's just say I made some calls. An $84,000 judgment wasn't the only serious matter Johnson was dealing with. He was also trying to obtain a so-called certificate of innocence in federal court in Pennsylvania regarding the criminal case where the Third Circuit had let him off the hook for impersonating an attorney and lying to the FBI. When the district judge denied it, he filed another appeal to the Third Circuit. And curiously, he had a kind of side quest going on there too, one that seemed to be awfully related to Think's case. He wanted the federal court in Pennsylvania to redact every mention of his date of birth. District Judge Harvey Bartle III had specifically included Johnson's date of birth in his ruling to make sure that everyone knew exactly which Joe Johnson Jr. was being discussed. But Johnson came up with a preposterous argument to try to have that undone, which would have the effect of making my use of his date of birth in the emails I sent in 2022, based on Judge Bartle's written opinion, seem not just retroactively unreasonable, but possibly in violation of some rule or law. Johnson now argued that the Eastern District of Pennsylvania's Criminal Local Rule 53.2, Civil Local Rule 5.1.3, Federal Rule of Criminal Procedure 49, and the E-Government Act of 2002 required Judge Bartle to redact his birth date. But the Criminal Local Rule applies to parties, not judges. Civil local rules don't apply to criminal cases. Federal Rule of Criminal Procedure 49 is totally irrelevant, and so is the E-Government Act of 2002. As usual, Johnson was an expert at abusing procedure. Judge Bartle granted Johnson's request in part anyway, I think based on nothing except the desire to shut him up. But that was not good enough for Johnson, who filed his third appeal in the case to the Third Circuit. This spectacular display of legalistic bullshit motivated me to put in the effort to write an amicus brief, and I was ready to file it. My brief would have been the only opposition too, because the United States Department of Justice decided that the issue was apparently too trivial to waste taxpayer dollars on, and declined to file anything at all. But the Third Circuit wouldn't allow a pro se litigant to file in the case without filling in forms, obtaining prior authorization, etc., etc., etc. For a lawyer, it would have been no problem. While I was arguing about my rights with the appellate court staff, the appellate panel issued a quick ruling in Johnson's favor, remanding it back to Judge Bartle. My amicus brief was too late. The appeal was already over. Then, in a different appeal of the same case at the Third Circuit, which had enabled this entire saga by letting Johnson out of prison, Johnson got more special treatment. The court appointed a group of Yale Law School students with a faculty advisor and an outside law firm to file an amicus brief with their perspective on the case. When they finally filed their brief, they recommended ruling in favor of Johnson, completely oblivious to his criminal history, even though I had told them about it. Fortunately, the Third Circuit thanked the Yale Law students for their service and promptly ignored them. The denial of Johnson's certificate of innocence was affirmed. On April 30th, I got some bad news. Not only was my motion to personally intervene in Think's Maryland case denied, but Judge Anderson had copied and pasted Johnson's proposed order. I was barred from personally filing anything else in the case. On top of that, the motion, with all the evidence of Johnson's history of vexatious litigation, was to be struck from the record as if it had never been filed. Instead of the vexatious litigant, who I could now confirm had filed over 200 lawsuits, being faced with a pre-filing injunction, I was. It was completely backwards. What's more, I had done some research and found a fascinating loophole in Maryland law that seemed like it could solve the problem of having to pay an attorney to handle the rest of the case, but now that plan was ruined. Maryland Rule 2-241A3 is entitled Substitution of Parties, and remarkably, by the simple act of filing a notice, it allows the transfer of interest in a case from one party to another. Since a notice is not the same thing as a motion, it doesn't require a judge's approval, and there's nothing in the rule forbidding a corporation from transferring its interest in a case to an individual. The problem was that even if I asked Dirk to file the notice for me as Think's lawyer, once I was substituted in for Think, the judge's pre-filing injunction against me, written by Johnson, would still apply. Plus, even though I was technically correct that I could file this notice, it probably didn't look very good right after a motion to intervene had been denied. I was stuck with Dirk. May 3rd brought even more bad news. 2 court orders from the day before popped up on the dockets in the Spirion and Geico cases. Administrative Judge Danica Varner-Cotton, whose sister Danaka Varner-Cotton is also a judge in Prince George's County, had denied my request to view documents on MDEC pursuant to the First Amendment. The implication of her decision was that if I wanted to look at other case records, I would have to either fly to Maryland myself or ask someone at a court in Maryland to look them up for me. But that didn't necessarily mean that you could save the files, just that you could look at them. Judge Cotton's order in each case was 1 page long. It contained no reasoning, no citations to precedent, and no discussion of the First Amendment. It was the judicial equivalent of just writing the word no on the page. This meant that Dirk and I would have to try to win the case without having the most important documents involved accessible. Sure, Dirk could probably go to a court and sit at the public kiosk for a full day trying to download all the documents Joe Johnson had ever filed or responded to, but he'd charge $450 per hour to do it. Did I really want to spend $5,000 on attorney's fees for that? A plane ticket and a hotel would be a fraction of the cost. I started thinking about whether I really needed to book a flight to Baltimore to spend a day at the infamous public kiosk. I felt like I was running an obstacle course while blindfolded and shackled, and all I wanted to do was get to summary judgment. But there were a few more monkey bars and jungle gyms to traverse. Johnson was pressing ahead with his attempts to get even more discovery documents out of Think, while at the same time refusing to answer a single one of Think's discovery requests. Dirk made this more complicated than it had to be by somehow overlooking Johnson's discovery responses in his email for 2 weeks, which made me think that Johnson had simply ignored the requests. He hadn't. Even though his responses were comically improper, Johnson hadn't ignored them. He just refused to play ball. In this one instance, the seeming lack of a reply wasn't Johnson's fault. Think just had a lawyer who had trouble with document management. Johnson also wanted to strike the responses I had provided and modify the case's scheduling order to extend the discovery deadline, one ludicrous request after another. It took not 1, not 2, but 3 protective orders issued by the court to shut him down. And that meant more of my time and more billable hours for Dirk. As a result, even knowing that Dirk paid, let's say, a lot less attention to detail than I did, rather than micromanage every single filing, which could get expensive, I let Dirk handle things, so he didn't even run the filings by me before putting them on the docket, because they were all so basic. One thing Dirk decided to do using his professional discretion was finally include a sanction in the proposed order that went to whichever judge would end up handling the motion. That's something I'd been asking him for a while. But on his own, he decided to ask for only $500, about an hour of his time, even though he had probably spent at least 20 hours handling Johnson's discovery nonsense. I had no idea that he had done this since the proposed orders in Microsoft Word format don't become part of the docket in Maryland. So I was surprised to learn that when Judge Anderson issued her 3rd protective order blocking Johnson's abusive discovery tactics, he had been sanctioned, but only $500. Getting Johnson to actually pay that $500? What can I even say? The tale of that $500 sanction could have a podcast of its own. Because if there's one thing a dedicated financial criminal doesn't want to do, it's write you a check because you figured out his scheme. But I had an even more immediate problem, because I had made my dissatisfaction clear to Dirk, and thus I'd committed the cardinal sin of clienthood. I questioned whether his bills were reasonable. In my view, Dirk had prolonged the case and made it considerably more costly by failing to represent Think's position accurately at the motion to dismiss hearing. He had filed an embarrassing answer that needed immediate correction, and he had misplaced Johnson's discovery responses for 2 full weeks. Dirk had a different perspective. "I do not care if you like to dicker about bills," he wrote. "That is not my style, and I do not tolerate it. If this bill is not paid immediately, I will withdraw from the case." Broken is produced by Think Press and PlainSite, which are both brought to you by Think Computer Corporation. With the exception of court audio, everything you hear or see on this podcast, the script, the sound design, the mixing, the graphic design, the music, the website, and the DALL-E image prompting, that's my doing. Until next time, I'm Aaron Greenspan.